Good morning, everyone. Welcome to this seminar. We're just going to wait a couple of minutes till people have joined. So you'll just have to look at me sitting here for a moment. For those of you who have just joined, we're just waiting for everyone or most people to join this seminar, and then I'll get started. Good morning, everyone. If you've just joined, we're just going to wait a couple of minutes for people, the bulk of people, to join before we start. So please get a cup of tea, and I'll be with you in a couple of minutes. Okay, I think we're just about ready to start. Looking at the number of participants, which is quite a healthy number. So let's make a start. Welcome, everyone. My name is Angus Walker. I'm a partner at BDB Pitmans, and as you may know, I specialize in DCOs, development consent orders, and infrastructure planning generally under the Planning Act 2008. This is my first Zoom seminar, so things almost will certainly go wrong. Please be forgiving. I have put a shirt and tie on, especially. It goes quite well with my pajamas. So I'd like this to be interactive. If you have some questions, please submit them. You have two ways of submitting things. So please could you use the Q&A button to send any questions or comments relevant to the talk. And if you use the chat button, which you should also have available for any technical issues, and then my colleagues will look at those and try and resolve them if they can. But obviously, we can't resolve everything if it's something at your end, for example. I've had 2 or 3 questions in advance, for which I'm grateful, so I'll cover those as we get to them. Now, this talk is about how we can progress nationally significant infrastructure projects during this exceptional time. I have written a 4-page paper, which I hope you were emailed yesterday, but we can send it out afterwards as well, which is tailored for applicants, but is a summary of a much longer paper that I and colleagues from the NIPA board, National Infrastructure Planning Association, that is, produced and submitted to the government with some suggestions about how to deal with all the various stages of NSIPs during this time. So the topics I'm going to cover are basically the things that you can't do at the moment, and how we can get around them. First one, which I'll probably spend a bit of time on, is that documentation can't be deposited because deposit locations are closed, or people can't travel, or even if they could deposit things, people aren't going to go to those locations to inspect them, so it would be fairly pointless anyway. Similarly, site notices are often required, and it may be that they can't be erected because people can't travel, or even if they were erected, people are unlikely to be going past them and see them anyway. Land referencing, that often involves a physical stage of going to the site and to nearby properties and inspecting them, knocking on doors and what have you, and that can't be done necessarily. Site surveys, often in preparation for an environmental statement, one needs to survey the land and to take readings of various things. So you may not be able to go to the site for various reasons, or even if you could, if you did the survey, it wouldn't actually be representative of normal life. If you're doing a traffic count or something, or a noise survey, you're going to get much lower readings than are representative. Consultation events. There is a statutory consultation for every DCO project, and everyone so far has had physical events that people turn up at and ask questions of the promoters team, and they can't be held because of restrictions on congregation. Similarly, hearings, once your application has been made, the planning inspectorate hold hearing, or the examining authority hold hearings, and are preceded by a preliminary meeting, which also can't be held. And finally, DCOs that were granted a few years ago, there are some that are reaching their the date by which they must be implemented, but there are difficulties implementing them. So what can we do about that? Okay, let's move on to the first topic. And for each topic, I will say give some examples of where this has been dealt with in other regimes, how it is being got round in this regime, then finally some recommendations, and then I'll invite any questions and answers you might have, or questions. I'm supposed to give the answers, aren't I? Questions or comments, and then I'll move on to the next topic. So the law requires physical deposit of documents and site notices in quite a number of places. So during statutory consultation, you must publish a notice saying where the documents have been deposited. Technically, it doesn't actually say you have to deposit. You could not be telling the truth in your notice, but I think the implication is you must do what it says in the notice. The statement of community that says how you're going to consult people in the vicinity is to be available in the vicinity, which implies that's a physical location. Once you've made your application and it's been accepted and you're inviting representations, again, you must physically deposit the documents and display a site notice. You must then, after the end of the representation period, you have to certify that you've done all the right things, which you can't certify if you can't do them. There is a process for adding new land to compulsory acquisition powers during the examination. That has a whole lot of deposit requirements, just like the main application. If hearings are being held, you are supposed to put up a site notice advertising the hearing, although at least in that example, the examining authority can say you don't need to do that. So it's not a hard rule. Once the DCO has been granted, you are required to put a site notice of the compulsory acquisition powers that have been granted. And finally, if you're amending your DCO, there are deposit requirements for material and non-material amendments. So rather a lot there. And here's why it matters. This is section 55 of the Planning Act. So in the red box, the Secretary of State may accept the application only if the Secretary of State concludes that the application has complied with Chapter 2 of Part 5 pre-application procedure. And that includes the regulations that say you have to deposit things. Underneath the red box, there is a more subjective test that the application is of a standard that is satisfactory, but that doesn't apply to complying with the pre-application procedure. Obviously, tiny errors in the procedure would probably be acceptable at any time, but is not depositing something when you're supposed to, does that comply with the law or not? Probably not. Let's look at other fields. So there have been some changes in the law in reaction to the coronavirus pandemic. The first one to happen was for local authority meetings. These regulations were passed probably about a month ago now, and they say that a document being open to inspection, in the red box there, includes being published on the website of the council. In other words, you don't need to physically have them open to inspection. Then another one, this is a week ago. Bays have sort of jumped the gun slightly compared with other government departments. And for environmental assessment of petroleum and pipeline projects, the regulations for inspecting copies does not apply, where the effects of the coronavirus mean it's not reasonably practical to have inspection. And then really hot off the press this morning, these regulations have come into force. They cover town and country planning, listed buildings, and environmental assessment of ordinary planning applications. And they have various requirements which say that if you cannot comply with the deposit obligations, then you comply with them as far as you can. You take reasonable steps to inform any person who is likely to have an interest in the application of the website that you put the documents on and publish them on the website. So that might be a parallel for what we do on NSIPs, but so far the law has not changed for NSIPs. So what's happened to projects that have had to tackle this so far? Well, I've got a couple of examples here. Highways England both of these projects, I should say, both started before lockdown happened. So we haven't yet had a process that's been entirely during lockdown. So on the A1 North Tuddenham to Easton project, the statutory consultation had started, but new notices were published. Documents were not available for inspection anymore and could only be found online, but the consultation has continued. Then at the representation stage, it had started again. This is the M54 to M6 Link Road project, but is continuing with an online-only inspection. This appears to have the endorsement of the planning inspectorate, but they're still inviting representations on their website. But in both these cases, the periods have been extended. Consultation and representation periods have both been, I think the M54 one was 6 weeks and is now 10 weeks. And I think similarly with the North Tuddenham one, a similar increase. So when I circulate these slides, or my colleague does after this talk, these are links there to the two notices, the revised notices, so you can see those. So this is something of a recurring theme, although it is generally possible to continue these processes with modifications, and the single greatest modification is usually to allow more time. So you will, if you do have a project on the go, you will probably need to allow more time. This is because it's going to take longer for people to learn about these projects, because inspect them and digest them and even send their consultation responses at the various stages. So NIPA have been recommending that the law is changed temporarily not to require site notices and document deposit physically, in line with those examples I showed earlier. And it would be very helpful if the that in the interim, as long as the applicant, I think it can't just be a blanket, it's okay not to do it. As long as the applicant can demonstrate there's no prejudice to the parties, that no physical deposit would be acceptable. So I'll have a short break now for any questions you might have. I'll click my question button. No questions. Well, I did have one in advance on this topic, which was question box is in the way of my question. Oh, apparently there are some sound intermittency problems. I'm sorry about that. I will soldier on. Perhaps you could leave and rejoin or something. So one question was, are there any lessons learned from the acceptance of the South Humber DCO, which is the first to be accepted since the restrictions came in? Well, I would say that there aren't any lessons yet. There is no, well, there has been no adjustment to that project so far. It made its application in the normal way. I looked at the Section 51 advice given when the application was accepted. It was standard. The acceptance was standard. So any lessons we learn going forward when they start their representation period, but that hasn't started yet. That'll be the first representation period fully within lockdown. But given that periods have been able to proceed with at least partly during lockdown, it should probably be possible for this to proceed. However, as I say, that there is a technical non-compliance with the law to project promoters, that there could be a legal challenge. But as long, I think that as long as applicants show no prejudice by compensating with additional activities, further ways of letting people know about things and giving them the ability to inspect them, then that should be okay. Oh, I've possibly got a Q&A now. Yes, thank you. You've asked some questions. Could the regulations issued this morning be reasonably used as a read across to NSIPs? Well, I actually asked that specifically of MHCLG, and they said they do not apply to NSIPs. And legally, if something applies in another regime, that doesn't mean you can read it across, unfortunately. Any likelihood that PINS will adapt its Section 55 checklist to acknowledge restrictions on complying? I haven't actually read the South Humber Section 55 checklist, but that might be something to look at. It may, but it's really checking the application was acceptable. So I would have thought that it would be better for it to say, better for the Section 51 advice accompanying acceptance to talk about what to do next. You mentioned temporary law changes. Is there perhaps a case for force majeure type provisions? Oh, I'm getting a message saying my connection is unstable, so you may be having trouble hearing me. I'll just pause for a moment, see if things recover. Trouble is, I'm blissfully unaware of whether I'm causing these problems or not. Okay, I'll repeat that last question. You mentioned temporary law changes being suggested by NIPA. Is there perhaps a case for force majeure type provisions in the Planning Act and Town and Country Planning Acts, etc.? Or are situations like COVID-19 rare enough not to warrant this? Well, that could, if something is challenged, that could be a reason for saying these were exceptional circumstances. That could be a defense for not complying. But obviously, an actual explicit change to the law would be a lot better. Okay, I've got some more. Done. Dismiss the ones I've answered. Is there any indication as to how long these modifications will remain in effect, or is it linked to the government's COVID-19 lockdown exit strategy? I don't know of any indication as to how long, and I suspect there isn't one because nobody knows how long this will go on for. I'll come on to DCOs being extended, the ability to implement them. In Scotland, there's just been a blanket, I think it's a 1-year extension. So that gives some indication of how long people think this might be going on. There is, in the regulations that restrict movement, it does talk about an emergency period, which can be declared to be finished by the government, and they have to review it every 3 weeks. Although I haven't actually detected that they reviewed it last week when they were supposed to, but anyway. So modifications could be tied to that emergency period continuing. That's one way of, that would mean that they would automatically finish once the emergency period had finished. Given the physical size of DCO documentation, if an interested party is unable to access any sort of electronic documentation, what is the best way to not prejudice against them being able to access the DCO documents, e.g. providing physical documents to an individual may prove impractical? Yeah, well, that is a tricky question, and one I haven't mentioned so far, but it is covered in at least the NIPA paper. Obviously not to prejudice people who don't have access to electronic means, where they would normally have gone to the library or wherever the documents were, is the most challenging area. I think that, well, the paper suggests that there are ways around it, like having a phone line that people could phone up and have the application explained to them, how it affects them. Or even if it's impractical or applicants are unable to print an entire application, given its value, often thousands of pages, and they are sitting at home and don't have access to complex printing facilities, there may be some smaller guide to the application that could be a summary of it that is able to be printed, or a non-technical summary to the environmental statement or something like that. So there are probably ways to deal with people who don't have access to the internet. And one must remember, of course, that even people who do have access to the internet may not have very large bandwidth, and these documents are often very large. So one must be aware of, as one should be at the moment, difficulty seeing complicated documents on a small screen that are very large, and perhaps dividing them up into small chunks. But some sort of summary document would be a good idea that is able to be printed and sent to people. Obviously, I'm not giving you legal advice today, but these are some suggestions. Force majeure would not apply as COVID-19 is a known event. Okay, that's a comment. Luckily, I don't need to answer that one, probably. Although the emergency period ends in September, see the first set of regs made in Feb, which allowed police to quarantine people. They last for 2 years. Well, yes, I think end dates are a bit risky for the government at this moment, and they should tie it to some sort of emergency declaration that once that's ended, then the restrictions would also end. Interestingly, though, of course, some of these restrictions or adaptations, rather, may continue after the end of the process, because I think that there are some advantages. Let's not assume that everything's more difficult. That, for example, remote hearings might be easier for some people who can't, if they're a long way away. People either have physical difficulty getting to them, or there's no public transport or something like that. Then if they were able to participate from home, that would be better, and that could be something that lasts beyond the end of the restrictions. Would the proposed temporary change to the law apply to post-consent notices also? Well, one would hope so, yes. All instances where site notices are required and physical document deposit is required. That's what we're asking for. Final one for the moment. Having made changes to other areas of the planning legislation regarding site notices, any reason why NSIP applications were not addressed at this time? Well, that's not one for me to answer, but it is certainly the case there are a huge number of things that the government has to consider simultaneously and coordinate. So it's no mean feat. And although NSIPs are by definition nationally significant, there aren't very many of them compared with ordinary planning applications. So it's probably natural that they have taken priority, maybe. But I'm confident, and I'm very grateful to government actually. NIPA is having a weekly call with MHCLG. There's one this afternoon. So we are hearing the latest of what's going on, and they are definitely live to all these issues, and I'm pretty sure they will get addressed soon. Okay, another one. Having made changes to other areas of... Oh, no, I've answered that one already. I think I've dismissed the wrong one. I think I can look back at the ones I was asked. No, I think I've answered all of them. Oh no, here we are. For a legal challenge on non-compliance of Section 56, that's acceptance, to be successful, would there be a need to demonstrate that a specific person or organization had been prejudiced, or could this challenge be successful purely on the theoretical? Well, one thing I should note is that once you've made an application, the Planning Act does not allow legal challenges until after it's been decided. So that's going to be a good 16 months later that a challenge can even be launched, by which time it's going to look rather old, given the amount of attention the application will receive during the examination, etc. So that's point one. I can't really say whether a court would say that theoretically, because things were not available, that prejudiced people who may not even have known about them, and therefore they can't be demonstrated not to have been prejudiced or something. But I think it would be more likely to have evidence for a challenge to succeed, evidence that somebody was prejudiced. But who knows? Right, I think I've dealt with all the current questions, so let's move on to the next topic. Other ones will tend to be shorter, I should point out, reassure you. So land referencing. At least in this case, there's not a hard rule. The law requires a standard of diligent inquiry when establishing who owns the land. However, this does normally involve going around people who are not on the land registry, or who didn't reply to notices, to letters asking them for what their interests were or others' interests, putting notices on land that the land referencers can't ascertain who owns it, and that may not be possible. But at least it's not a hard and fast rule. But the solution again is similar, that other activities that can be carried out should be stepped up. The NIPA paper gives examples of some of these. And you should probably allow more time in your pre-consultation activities for land referencing. I mean, other activities could be by sending more letters to people, phoning them up if you can find their phone numbers, asking whether they know about other people's land holdings, that sort of thing. subject to data protection requirements and things like that. So no change in the law is needed here, but it would be helpful if there was some sort of reassurance either from the planning inspectorate or the government that modified land referencing activities can continue and would be acceptable. Any questions on land referencing? It's quite a small point, but an important one. No? Okay, let's move on to site surveys. So this is probably the second most significant area. So why does it matter that you need to survey the sites? That almost all nationally significant infrastructure projects do require environmental impact assessment. Applications must be accompanied by both an environmental statement and a report on any Natura 2000 site which may be affected by the proposed development, and sufficient information that will enable well, it originally said the Planning Act, the Commission or the Secretary of State to make an appropriate assessment of the implications for the site. These are the highest level of international protection sites, like special protection areas and special areas of conservation. So, what is an environmental statement? Well, it's defined now. It didn't used to be, but it's defined in the 2017 Infrastructure Planning Regulations, Environmental Impact Assessment Regulations, that it is something that includes at least a description of the likely significant effects of the proposed development on the environment. So, in order to establish what those likely significant effects are, one must measure what the environment is like at the moment, add onto it what the impact of the project would be, propose mitigation, and report on what residual impacts there might be. So in terms of physically going onto the site, the NIPA paper has a link to a letter that was sent to the CIEEM by the government, and I've extracted a sentence there. Ecologists and environmental professionals should therefore be able to continue with outdoor work, including ecological surveying and supervision, where they can continue to follow Public Health England guidelines. So in principle, it is still possible to continue to survey land at or around a project. But as I said earlier, even if you could do it, your readings may not be representative. So you may measure air quality and it may look fine, and then when you add your project it still looks fine, whereas in reality, if it was normal life, if you added your project to the current air quality, it might not be fine. So therefore you would not be properly assessing the effect of the project. So how do we get around that? Well, here's an example from not from an NSIP at all, but from HS2. This is not in COVID world. This is just even now. It says access was not obtained to all the land where surveys were proposed. This is for phase 1 of HS2, the one that's now under construction. In addition, delays to access have meant that some surveys could not be conducted or were not conducted according to the method laid out. Blah, blah, blah. Therefore, in order to ensure that all likely significant effects of the proposed scheme have been identified, where baseline information is incomplete, a precautionary approach to, I'm not quite sure why they've used the word valuation. It may have meant to have been evaluation, but anyway, a precautionary approach to valuation has been adopted, assuming a reasonable worst case. So those last 3 words may be the key to unlocking this area. That where you can't measure something, you assume it's as worse, not absolutely as worse as possible, but as reasonably can be assumed to be as worse as possible. So if you can't find some species that you think might inhabit your land because you can't get to it, you should assume that the reasonable worst number of that species is in fact present on the land. Of course, this does have a downside because you will therefore have to propose mitigation to deal with something that probably isn't even the case, and have to earmark other land for further compensating habitats or something like that, which would be much more land than you will probably ever need. And the environmental impacts that you're reporting will look worse than they really will be, probably. But this may be a way around if you have done some surveying but can't do all of it. So once again, there's no change in the law would be necessary here, or even if one was made, it wouldn't be that useful. And as I say, a possible approach, as long as your gaps aren't too huge in your environmental statement, you can use this reasonable worst case approach. You could then have a sliding scale of mitigation, so you only need to provide it if the worst case materializes. And if it's less than the worst case, you do less mitigation and so on. So it's adaptive mitigation, if you like. I think you probably should deal in your DCO or in your environmental statement, or both, with the actual situation being worse than the reasonable worst case you reported. So what if your assumption of what a reasonable worst case is was in fact not, you underestimated what the worst case might be, and it turns out to be even worse. So some sort of process of stopping and getting some further approval or something like that, having assessed what and mitigated against the thing that was even worse than you thought it was going to be. I mentioned habitats earlier, and there is a contrast to be made between ordinary environmental effects, if you like, which are just a balancing act, where you fall in the test at the end that your DCO should be approved if the benefits outweigh the adverse impacts. So the adverse impacts are merely balanced against the benefits. But there are some impacts that are absolutes. So a habitat cannot be harmed, whatever the benefits of your project, without certain mitigation or compensation or permission from the EU or whatever. Similarly, water quality and air quality, if you are going to exceed the limits on air quality, doesn't matter how brilliant your project is, it can't be consented. So pay particular heed to those absolutes. Right, I've got some cute questions here. Let's have a look. Should a landowner refuse access to land on COVID-19 issues, could access be enforced legally, and would it be wise to pursue? Well, that's quite a topical issue because there is a process under the Planning Act that already existed for compelling access to land for environmental surveys. But there has been a recent court case in relation to the Stonehenge project that implies that a much simpler process in the 2016 Act, the Housing and Planning Act, yes, I think so, can be used instead, which merely give notice to the landowner. If they refuse entry, you can get a magistrate to say, no, you should be allowed entry. Because the process under the Planning Act is very lengthy. It takes about 6 months, so that's not very practical. So it might be worth trying this Section 172 process instead. Next question. How might a reasonable worst case be applied to noise survey and assessment in the absence of a representative noise baseline? Well, I am not a noise expert. But I suppose in the case of noise, surely if your baseline appears quieter, then that will make your project look worse than if it was a typical noisy day. I'm not sure. Oh, yeah, I think you're going to have to ask a noise expert that one, but there may still be ways around it. I wonder how assuming a reasonable worst case works with compulsory acquisition regulations. If land is subject to compulsory acquisition, where there is not a risk that landowners could challenge whether this land is essential if it is required for mitigation for a species that may not be present or may be present in lower numbers than assumed. Yes, that is certainly a consideration. If your reasonable worst case is including some land for mitigation purposes that is very unlikely to ever be needed, then it is quite likely that the landowner will reject compulsory acquisition. Well, the compulsory acquisition might not succeed. So it would be better to do this mitigation on land you already own or land you can reach agreement with the landowner with. But I'll think about that a bit afterwards. I think I can't really answer that one on the hoof in detail. Is there any emerging guidance on discharging environmental related DCO requirements post-award potentially affected by COVID? I have a project that requires continuous air quality and traffic monitoring for a year to compare with ES surveys done during the DCO application in 2016 to establish mitigation where there could be a 20 to 30% delta. Well, I will get to implementation in a bit, but I have to confess I hadn't prepared that element of it. I'll have to think about that. So I'll leave that one open for the moment. How would this approach apply to traffic surveys? Would the 2020 data be exceptional and take an extra year back to make an average traffic increase? Well, again, traffic is going to be one of those where it does matter, because adding your project to hardly any traffic is going to not appear to make any junctions or whatever congested, whereas in fact they may well become congested. So if you can't adopt a reasonable worst case, you may have to wait, or some approach or some estimate or something. If you've got oh, I think there may be noise issues again. I'll just pause for a moment. It's telling me my connection is unstable, which usually means you can't hear me. The traffic surveys, as I was saying, is one of the areas that needs attention. So I mean, it is possible that you can't get around this, to be honest, for some of these impacts, and you may have to wait, but this won't have to be the case in every situation, and there may be creative ways that I haven't even thought of, or others haven't suggested to me, to get around this. So do keep thinking about it and working on it, and together we may be able to solve this. How do you envisage the compelling case for compulsory acquisition impacted by taking a greater, well, I've answered that one already. It is going to be more difficult to demonstrate a compelling case for compulsory acquisition if it is only in extremis that you might need the land. Would it be appropriate for applicants to spend more time to agree reasonable worst case scenarios and assumptions with the regulators and host authorities where surveys cannot be all undertaken? Well, yes, of course. I haven't actually said that, but I think I may have mentioned it in my paper, and it's certainly in the NIPA paper. But agreeing as far as you can with Natural England and other environmental regulators, the Environment Agency, what you're proposing to do would obviously add strength to your arguments of how you're dealing with it. Good point. Thank you, Ben. Is COVID-related health and safety a valid reason for refusing entry under a Section 172? Well, it might be, but if it's just some open land, then I can't see that any other person other than the people doing the survey would be impacted. but maybe you need access inside buildings that are occupied or something. That would be fairly unusual. So, the Cornwall case suggests that sufficient baseline information on flora and fauna is required to inform a planning decision. This was a town and country planning application. If reasonable worst case had very little data underpinning it, would there still be a considerable challenge risk, especially with regard to European protected species? Well, yes, I'd say European protected species, as I highlighted, are a special case, and you may not even be able to adopt the reasonable worst case without any real information about them. And there is a cutoff after which your environmental information is sufficiently sketchy that even a reasonable worst case probably won't be sufficient. But it's a matter of facts and degree in each case, I imagine. Does this present a strong case for investment in nationwide data sharing from surveys to better inform the assumed reasonable worst case? Well, obviously having publicly available data that people can access would be a good idea. And some sort of maybe requirement to publish might be a good idea, subject to data protection, etc., and proprietary information and all that sort of thing. Something to think about there. The lessons learned from this whole thing. Can you remind us of the legal basis for reasonable worst case in the normal situation, remembering that the requirement is to assess likely significant effects? Well, I probably can't tell you off the top of my head, but I think that if you're saying that these effects are worse than is even likely, then by dealing with them, you are therefore assessing and mitigating against the likely significant effects by going beyond them. But it's not set out in those terms in the law, I have to accept. But as I quoted from HS2, this isn't a new approach, but it may have to apply more widely. Okay, that's enough on those probably for the moment. I mean, it is a tricky issue, obviously, environmental assessment, reasonable worst case and all that. I'm not an environmental professional. Oh, I've got one more. Oh no, that is one I'd already seen. So that was the one that I haven't actually dealt with is on having to monitor post-consent and then not getting realistic survey readings. What does that mean? Well, I might cover that in a minute, or if I don't, I apologize. I'll try and follow up afterwards. So let's move on. Consultation events. The law requires a statement setting out how the applicant proposes to consult about the proposed application, consult people living in the vicinity of the land. That is the SOC, Statement of Community Consultation. The applicant must also have regard to any guidance about pre-application procedure. And there is guidance, and there's an example, paragraph 57. The Statement of Community Consultation should act as a framework for the community consultation generally. For example, setting out where details and dates of any events will be published. So the assumption is there will be physical events. However, these can't really take place at the moment. But the law does not require physical consultation events to take place. One must merely say what you're going to do in the SOC, having previously consulted local authorities on that. So you're allowed to say you're not going to have any physical events. However, as usual, you will need to compensate for doing more in other ways. Let's look at practice briefly. So no project has conducted full statutory consultation since the start of the lockdown. I mentioned the A1 North Tuddenham to Easton, which extended its consultation. The Lower Thames Crossing, although it had already had a full statutory consultation, this was a supplementary one. and it had had most of the events. The last two were after lockdown, so it held them online instead, where you could speak to the experts by phoning them up. There's a link to how they did it on their website that you'll see on these slides. So that's how practice has happened so far. So a possible approach. So if you've already issued your SOC and it says there are physical events, you're going to have to reissue it, really, to say you're not going to have physical events. Unless there were just one or two left as those examples. You will have to step up the compensating non-contact activities to achieve the same standard of reaching people and standard of consultation. And that's one area that you may be able to improve on the existing assumption that people read newspaper notices and therefore you don't have to do very much on top of that. So I think this is an example where we can be better than before. Consultation companies who specialize in consultation are developing online systems for hosting online consultation events. So I'm not going to give any names, but do consult them, do ask them. One issue I should highlight, I think, is that statutory bodies who are required to be consulted are obviously having their own difficulties with lockdown, that they aren't in their offices, they may be ill themselves or caring for people or furloughed or whatever, so or have different ways of being contacted, like their work emails might not be working or something. So it's definitely strongly recommended that you check in advance before you embark on your statutory consultation that you are contacting statutory bodies and they are in the right way, and they will be able to respond the way you're doing it. So in terms of recommendations, again, no change in the law is needed because there's no requirement to hold physical events in the Act or regulations. But once again, some sort of reassuring statement from the government or the planning inspectorate that online consultation events are possible to continue if appropriately adjusted would be reassuring. Okay, I've got a couple of questions again, have I? Does a SOC need to be revised or updated with host and neighbouring authorities should digital events substitute for physical events? And would the 28-day period for authorities to respond need to be applied again? Well, I think if you haven't started your consultation but you have consulted on your SOC and it talks about physical events, I think it may be that you should reconsult on it because you're going to have to propose alternatives that will, so it's not just that you're not doing physical events, but you're doing something else instead, that it's probably a good idea to consult the local authorities on to avoid a challenge. So I'm afraid it may be necessary that you'll have to add another 28 days, but you might be able to get the local authorities to respond sooner than the 28 days if they're on side with progressing your project. That's not always the case. There's been some discussion about the merits of flexibility in the SOC because of COVID-related uncertainties. What is your assessment of how receptive local authorities will be to this and the dreaded woolly SOC? Ho, ho, ho. Well, flexibility in a SOC is recommended anyway, to say, particularly if you're going to have a further mop-up consultation, to mention that. But completely adapt, you can't just say, well, we're going to do something and we're not really sure what it is probably against the spirit of what a SOC is. So I don't think you can make it completely woolly. A cotton polyester mix is probably recommended. But some flexibility within limits, as long as you're demonstrating that you are achieving some sort of standard of consultation, is no doubt possible. If you have a SOC that specifically identifies the duration of consultation, but you then actually extend it because of COVID-19, i.e. clearly a beneficial step, would you still need to revise the SOC? Well, that may well be an example where you might not need to. For example, that A1 project extended its consultation, so did Lower Thames Crossing. I don't think they reissued their SOCs. So that's probably an example where it's okay. And I think prospective applicants should be more forgiving of late responses as well, because people may have difficulty responding or assessing an application because they're reading the documents online and what have you. Okay, I'll try and finish not long after 11:30. We've got one more. Will a SOC be required for any targeted non-statutory consultation as a result of feedback from statutory consultation and scheme changes? Well, SOCs are not required for non-statutory consultation because it's by its nature non-statutory. And often there is a mop-up statutory consultation because a project has changed in some small way or new land interests have been identified. But one would hope that the original SOC allowed for those further consultations itself rather than needing a new one. But you definitely don't need one for non-statutory consultation. Okay, let me close that window and see what's next. Hearings. Well, in a sense, once you're from the point from when the application goes, or rather from when the examination starts till the decision is made, that's the planning inspectorate's problem, not yours, you applicant's problem. And they are indeed actively designing online hearings and preliminary meetings. 2 live examples there with links to their web pages. So the A38 Derby Junctions project had its hearings suspended that it was about to have because of lockdown, and is now planning a series of online hearings from the 9th to the 18th of June. Similarly, M25 Junction 10, which had a compulsory acquisition hearing that had to be suspended, is again going to hold it online, hopefully, between the 16th and 18th of June. You can tell by those dates that those are longer than the hearings would probably have normally taken, and that is one of the compensating effects of having them online, is they probably will take longer and be more spread out. So as an applicant, you should probably expect that. Also, both those projects have had their examinations extended by, I think it's 5 and 2 months respectively, although they may not take up that whole time. So that's another thing applicants might have to accept. Although maybe these were ones that were ongoing, had a couple of hearings towards the end that couldn't take place, and so maybe that's why they got extended. And once the non-physical hearing regime is in full swing, it will not be necessary to extend examinations, we'll see. But for the moment, it's quite likely they will have to be extended. Oh, that's it on hearings. Don't have any. So if you have any questions on hearings, and there is that point about the site notices I mentioned earlier, but I hope examining authorities would waive the obligation to erect a site notice because they can do so. Okay, no. I mean, do examine and monitor these 2 applications because they are the leaders in the field of online hearings. I was asked in advance, do you have any intel on how examinations may be run in the new normal? Well, that's the intel. I mean, the Planning Act, luckily, in the first place, is predominantly a written process, and so it can largely carry on as normal. The only case where it can't, no, actually, pause that. It's not the only thing that can't happen, is hearings, but we have had some town and country. I think we've had one town and country planning hearing earlier this week, and they are going to be held for NSIPs next month. The other example is site inspections. So accompanied site inspections are difficult because of social distancing, and even unaccompanied ones are quite difficult. But again, this is something that is common in town and country planning and is being tackled there. I think unaccompanied site inspections in particular are likely to restart, and who knows, even accompanied ones, or where the inspectors go on the site and are in touch with other parties who are pointing things out maybe, or something, but some sort of substitute accompanied site inspection may be able to continue eventually. I've got a couple of questions now. What are your views on preliminary meetings that have not yet happened and had to be postponed due to COVID? Is it likely that PMs will be held virtually as well, and what is the risk of challenge? Yes, it is likely that PMs will be held virtually as well. And I think there were a couple, like the East Anglia 1 North and 2, were about to had dates for PMs. I think Ackwind, maybe another one, that got suspended, but I think Planning Inspector are actively planning online preliminary meetings for those. What is the risk of challenge? Well, there is no, I think the law doesn't require a preliminary meeting to be held in person. Meetings can be held, are being generally held, planning meetings, court hearings, all sorts of meetings are being held virtually. So although there is always a risk of challenge, I think as long as no prejudice can be demonstrated, it should be possible to minimize the risk of a successful challenge. Do you think preliminary meetings can be virtual rather than socially distant? Yes, I do. Just like other hearings and planning meetings, it should be possible. If you look at the Derby Junctions project, the planning inspector asked various questions of people about how they would be able to participate. And so you can see what they're thinking about, and I think that would apply equally to preliminary meetings. PINs seem to be struggling to make the virtual hearings available to the wider public, e.g. through live stream. Is this a challenge risk? Well, I think that those who are not actually participating in a hearing, it should be okay if they simply listen to a recording of it afterwards, just as now. But those who wish to participate, wish to hear it live, even if they're not going to speak, I think should be given the opportunity to do so, just like a real hearing. And I don't see why that's not possible with the various online facilities available. People have their opinions about Zoom, but it is accepted in some cases. And then there's other methods like Skype and Microsoft Teams. And I'm sure that attending but not participating people can generally be added to such applications. Completely replace door knocking or to complement it? Well, it's a question of balance, and I've been told I'm unstable again. I'll wait a moment. Hope things have recovered. It is a balancing act and a matter of judgment by land referencing professionals, I would say, that they have discharged the diligence inquiry threshold. If some door knocking can take place at a socially distant, in a socially distant way, then that may be advisable. And it's up to them whether they consider that replacement activities fully compensate for the lack of doing that. See, I ducked that one. Right, let's move on to the final topic. If I can move my slide, there we are, implementation. So generally, DCOs say they must be commenced within 5 years, and while the threshold for commencing, as with implementing any planning permission, is pretty low, you do have to do something. Some projects are nearing that deadline and may not be able to get onto the land. And although compulsory acquisition, which also has a deadline, may not be affected directly because it's not a physical process required to go onto the land, it may be tied to starting the development, because that's the access to funds and so on gets unlocked and that sort of thing. So it is all one consideration really. And that is something where we as NIPA, that is, are asking that developments are able to be extended where it is impractical for them to be implemented in time. And this has happened in Scotland generally for planning permissions, but has not yet happened for NSIPs. It has to be said that NSIPs are different from planning permissions, but they are, DCOs are statutory instruments themselves. They are the law. So it may be that each one will individually have to be amended, or some sort of bulk amendment of DCOs. And that may itself be difficult because there isn't a direct mechanism to do that in bulk in the Planning Act. So it's a tricky one, but it is something that is actively being considered by the government. And I think they will also have to actively consider that difficulty that someone helpfully pointed out of complying with discharging requirements where readings are having to be taken at sites as well. So I think we will add that to our the points we make to the government about difficulties in implementation. So thank you for that one. Right. Oh, there we are. That's the example from the Coronavirus Scotland Act 2020. During the emergency period, so that's with reference to however long that period is, a planning permission which would otherwise lapse will lapse at the end of the extended period, which is set out later, unless before the end of the extended period, the development to which the permission relates is begun. So there's a way of possibly extending DCOs, but it may need primary legislation, which may be difficult to come by. So those are all the areas I was going to cover. If you have any final questions on something I didn't cover or something I did cover, now's the time to ask. Here's one. Do you think the temporary measures you have discussed that have been implemented during the current crisis will eventually have to become permanent measures? How will that affect the future of DCOs? Well, that's quite a big question, but I do think that some of these temporary measures may last beyond the pandemic because they are seen as beneficial, and perhaps a evolution to online only working was going to happen anyway, but has been accelerated because of this. And measures that allow remote people to attend hearings might be permanent because it does increase access to people who wouldn't physically be able to attend a hearing. So yes, I think there will be some permanent effects of this pandemic, some of which, or most, I would hope would be beneficial and further increase access and participation in these projects. Okay, any last questions from anyone? Yes. How many DCOs are due to expire in the next year? Not many. Yes, it is only a handful, something like 5, and of those, some have been implemented, some are never going to be implemented, and there's really only 1 or 2 that are actually affected by the fact that they can't implement themselves. So it's not a huge issue, but obviously for those projects it is a huge issue. Government were increasingly extending the 3-month decision period before COVID-19, which is reducing certainty of the regime. Do you think COVID-19 will make this worse? Is NIPA pressing government to make some decisions? Yes, NIPA is pressing government to make decisions. At least we have had no new delays, and all the ones that have been delayed without a date being given have now been given dates. The government is obviously acutely conscious of not wishing to extend deadlines, but obviously it does reduce confidence in the regime. But these are exceptional times, and the government is having to deal with a huge number of issues. So it's not going to be impossible that there will be further delays, but we will be pressing the government to keep them to a minimum, indeed. One more. Are you planning a similar briefing on anticipated changes to the application of consents under hybrid bills? That is something that we could certainly consider, probably not something for me to deliver myself, but maybe one of my parliamentary agent colleagues could do that. There I am, landing them in it. And indeed, on this briefing, I think I could well deliver it in 2 or 3 weeks' time again, adapted to events that had occurred between now and then, and taking into account the comments you have made, for which I'm very grateful. So what will happen now, I'll finish in a moment, but we will send you the slides. May send you another copy of the briefing if you haven't received it already. The debate, I will try and answer the questions with the submission of the slides, and we will consider holding another session in a few weeks' time. So, thank you very much for your participation and attendance. I hope you found it useful. The final question I was asked was, how on earth can people keep in touch with all of this going on, because there's so much going on that it's impossible to keep tabs on it. I definitely empathise. We at NIPA, and also as an individual practitioner, I will certainly be trying my very best to keep on top of this, and NIPA will be issuing regular bulletins, and I will be maintaining my blog with as many developments as I can find. So do keep reading, keep monitoring the NIPA website. We will send out emails if you're a member. You should get those. Otherwise, keep reading my blog as well. One last question. Service of notices is deemed to be correct if notices. Oh yes, that is an issue that is mentioned in the longer NIPA paper, that there are notice service requirements. The ones that require registered letters to be sent to official addresses only apply in certain circumstances, like compulsory acquisition. But that is a point that we've asked that gets waived as well. And we're also asking the government to introduce a general ability to waive impractical or unimplementable procedural requirements. This does exist in the Country Planning Act, the Transport and Works Act regime. So it is, and is being used under COVID in that regime. So we'll see if that gets implemented in this regime as well. Right, I'm going to draw things to a close. It is now 11:45. Thank you very much for your attendance. I hope you found it useful, and it's goodbye from me.